Hey there, I'm Paul Rabelais. I'm an estate planning attorney. I help our clients around South Louisiana get and keep their legal affairs in order. I've been getting a lot of questions lately that sound something like, Paul, how do I protect my assets in case I get sued? And, whenever I hear that question, I'm like, bells go off and I'm like, okay, this is, this has got to be a really important conversation. We got to have the conversation the right way. Can't jump into anything too fast. Here's the problem. In many cases, that question doesn't come to the estate planning attorney until after something happened. Somebody got in a wreck, some business matter went south, some big debt can't be repaid, and so people start to freak out. Oh, geez, I'm going to get sued. And that's really not the right time to start, planning to protect what you have in case you get sued. So it is a slippery slope. And so I do want to just educate you and dispel some myths about just general law and regulations on what kind of things that you may own are automatically protected from somebody taking something away from you, and then what things are exposed to lawsuits. Let me hit another item I see. Some people, they get scared. They think that just because somebody might sue them, they're going to lose everything. So our judicial system is set up where everything's going to stay put with you. Yes, you might get sued one day and still nothing's going to happen to your assets. They'd have to go through that entire process. They'd have to, state their case and they'd have to get successful, judge, jury, whatever. Then they would have to successfully get a judgment against you. And then again, it would be where your personal assets would be at risk. It would be a judgment that would exceed the perhaps liability insurance limits that you have. And then after all of that, now the personal assets are potentially exposed. So just all of that leads me to, if you live in Louisiana and you're worried about it, let's just go through the short little laundry list of what is protected that you own and what is not. So I'll start with things like cash value of life insurance on policies on your life that you own. That stuff is protected. Most people don't have a lot or the bulk of their wealth in cash value of life insurance, but it is protected. If you own annuities, they're protected. There are some little exceptions to these rules, so don't take any action without talking to somebody who knows what they're talking about. So annuities are exempt. Some people get sold annuities, a $100,000 annuity, it grows tax deferred. When you take the money out, the gain is subject to income tax, goes to your beneficiaries outside of any kind of probate when you die. So anyway, those insurance companies sell annuities, those are exempt. People who own IRAs are exempt. Now we're talking some of the big money here, because many employees of employers worked for many years, built up a 401k, they retired, they rolled their 401k into an IRA, and their IRA can't ever be taken from them. There was a 2014 United States Supreme Court ruling that said that if when that IRA goes to your non-spouse, children for example, then it's no longer retirement funds and it's no longer exempt from their creditors. So if you leave it to your spouse, okay, still protected, but if you leave it to non-spouse, not protected. So be aware of that 2014 United States Supreme Court ruling. But if you were the employee and you built up your IRA or 401k and you retired and you rolled your retirement funds into your IRA, that's protected. It's also protected in the 401k as well. Home, not exempt except for just a small portion of equity. In other states, the home is exempt, not in Louisiana. Now, let's lead to some things that are not exempt. Things that if somebody does successfully get a judgment from you, what could they seize? Well, they could take your home with the exception of that minimal, I think it's, escapes me at the moment, I think it's maybe $35,000 of equity. So people could take your home. Your savings that you have, that's not part of your IRA. You know, if you have bank checking savings, CDs, that's at risk. If you have investments, sometimes people call them non-qualified investments. Maybe you have at the brokerage firm, you have your IRA that is exempt, and then you have your other investments that are in an individual or joint account, perhaps with your spouse. Those are not exempt, so those could be taken. Interest you have in a business or real estate, LLCs, all that is not protected. So what do people do that want to protect what they have? And again, slippery slope, because it's a timing issue. You know, if and I hate to just sound trivial, but about if you get in a car wreck and you kill someone or you maim someone, if you try to engage in some of the legal strategies to protect your assets after that action has already taken place, you certainly run the risk of someone attempting to undo those transactions, because maybe they'll argue that you did it with the intent to defraud a creditor. So again, in advance is really the ideal time. For some people, this is their biggest worry, because maybe some minor event happened in their life and they're worried about a more major event. Heck, if you just drive down the highway in Louisiana for any length of time, you're going to see dozens and dozens of lawyer billboards. So as we all know, at the drop of a hat, it's unfortunate, but it's the way it is. Lawsuits are being filed, probably hundreds of lawsuits filed every day, and many of which have little or no merit. But it's just the system that we live in, and it's unfortunate. So that's a whole nother story. But all of that creates fear in the consumer's mind that if something goes wrong, everything's going to be taken away from me. And it's not, it's not an unreasonable fear. So what are people doing? And again, I started this with timing is important. So some people are taking their non-exempt assets and converting them into exempt assets. Makes sense? Some people are transferring assets out of their name. And if they're going to transfer assets out of their name, then the discussion is, well, to who or what do you transfer your assets to? It doesn't make a whole lot of sense for parents just to put a bunch of assets in their children's names. Yes, that might help things if the parents get sued in the future, but what if the children get sued in the future? So, pick your poison. Now, some people say, well, I'll create an LLC and I'll put my assets in my LLC that will protect them. Now, again, that's a bigger discussion, but I realize many people, and it's wise to do it, put their rental real estate in their LLCs, so that if there's a big problem, somebody gets injured on the rental property, the injured party will sue the owner of the property, the LLC, and the LLC owner's other personal assets will be protected. But you can't just put your CDs and your investments in an LLC and expect all of that to be protected from your personal liabilities if you go out and get in a wreck. Because if you have somebody sues you personally, they can take any assets that you own, including LLC interests that you own. So just know that it's not a quick fix just to create an LLC and put everything that you own in an LLC. A lot of people are using trusts these days, but they have to be very particular types of trusts. Again, I'm just going to scratch the surface here, but if a parent or parents transfer assets that they own, maybe non-exempt assets, into a irrevocable trust for the benefit of their children, I'll call it a irrevocable spendthrift trust for the benefit of their children, then in the future, if the parents get sued, the parents don't have any right to these trust assets because it's in a trust for the benefit of the children. So creditors of the parent or parents can't take those assets. And then because it's in an irrevocable spendthrift trust for the children, The children don't have any access to the assets until the trust provides that they do, or perhaps until the trustee makes a distribution to the children. And since the children can't go in and access the trust assets, and because by definition it's one of these called spendthrift trust, then creditors of the children can't get at the trust assets. Again, I almost feel like I'm going too far. This is not legal advice. Don't go out and take a bunch of actions solely on what you're hearing me say today, because there's more to it than that. But I'm just trying to give you the big picture on this an initial kind of protect my assets in case I get sued discussion. So this is the roughly 10-minute quickie version. Any serious action on your part needs much more back and forth discussion, much more particular views of what you own, what your family circumstances are, what your biggest concern is, what your exempt and non-exempt assets look like. Are you married? Do you have children? Do you have a prenup? Where are your children in their lives? Are they minors or are they adults? Do you have grandchildren? What kind of business do you have? If you have a business, all of those things factor into what an appropriate protect my assets from lawsuit program might look like. If you've got some additional information that you want to share it in the comments below. If you've got some personal experience, share it in the comments below. Feel free to subscribe to the channel so that you stay informed for future reference. You can go ahead and hit the like button if you'd like. And I look forward to continuing this discussion or watching you perhaps continue the discussion in the comments below. And hopefully we can all shed some light on each other as to just smart legal strategies. Nothing crazy, nothing outlandish, but common sense things you can do to protect what you have for yourself and your family. So I'm Paul Rabelais.